Now, as you noticed in the title, it was a trick question. And you are likely asking yourself, hey, Miss CRS, how is this title a trick question? Well, the first thing you need to know is the best way to support this channel is by purchasing some badass merchandise like the CRS rocker that has a Velcro backing that allows you to place it directly onto your rage bag, and you can get those at shopping at onlytacticalfans.myshopify.com. How is the Second Amendment a trick question? And it is not just a trick question, it is the trick question. It is the very question that allowed gun control to happen in the first place. Because when it is phrased that way, it implies that it is granting privileges. So then you are stuck in a position where you are trying to justify what privileges it does or doesn't grant. However, if you look at how the Constitution is written, it starts with we the people, because the Constitution is written from the people to the government. So essentially, the Second Amendment doesn't grant anything. What it actually does is limit the government's ability to put restrictions on the rights of the people to keep and bear arms. And what wordage do they use exactly? And how limited is the government actually? I quote, shall not be infringed. I apologize for my excessively long rant, but I need to lay the framework for the video so we are all on the same page. And so you don't think I'm some kind of conspiracy theorist chick on the internet that is going to transition into space Nazis. Alright, so let's get into the meat and potatoes of this video. So this story starts on a cold October day in 2020. Madison Lara, something like that, and the Second Amendment Foundation filed a lawsuit against Pennsylvania that their ban on 18 to 20-year-olds getting a concealed carry permit is unconstitutional. Now, referring back to our conversation we just had, and I'm not talking about the space Nazis, we already know they are correct because the Constitution overrules all other laws. However, this is 2 years before the Bruin decision happened, which is forcing justifiers to refer back to the Constitution when it comes to gun rights. At this point in time, the case law we are living under was called the Heller decision. Unfortunately, that particular case law says you can balance constitutional violations with perceived public safety. Essentially, if they can argue that banning 18 to 20-year-olds from being able to conceal and carry, it will somehow make things safer. The judges are instructed to look past the obvious constitutional violations. However, the Heller decision was a double-edged sword because it also clarified that the Second Amendment protects a person's right to carry inside and outside of the home. So back to the story. April 16th, 2021, they lose their case to give 18 to 20-year-olds the ability to get a concealed carry permit. The same day, they also filed for an appeal on the Third Circuit because the district judge's decision was still infringing on the Second Amendment. And then we have some movement. The appeals court held a decision pending the Supreme Court's ruling on Bruin because they were very similar cases. The Bruin case was about concealed carry in New York State. The Bruin decision dropped June 22nd of 2022, and it clarified and gave clear guidance on how to give judicial tests on laws that may or may not be infringing on the Second Amendment. And that test goes a little something like this. The two-step framework is no longer valid, and it is irrelevant whether or not there is a safety factor. Now, what the government is required to do is provide clear evidence that their law existed around the time of the founding of the Second Amendment in text, history, and tradition. And needless to say, they failed epically. So on January 18th of 2024, the three-judge panel found Pennsylvania's prohibiting on 18 to 20-year-olds conceal and carry an infringement and ruled the why can I never say this word? Prohibition, you guys know what I'm trying to say, unconstitutional. They found it unconstitutional. The government applied for an en banc rehearing, which would be a full bench, all justices from the Third Circuit would hear the case. Now, on March 27th of 2024, the en banc hearing was denied, at least for now, shutting the case in the Third Circuit, which covers Pennsylvania, New Jersey, Delaware, and U.S. Virgin Islands. So at least for now, 18 to 20-year-olds are protected by the Second Amendment, even though everyone should be protected by the Second Amendment. This case or a similar case will have to go to SCOTUS because we have a split in the circuits right now. Some are in favor and some are not, which is why the Supreme Court needs to bring the unification and clarification in the circuits. So what's likely to happen when one of these cases hits the Supreme Court? 18 to 20-year-olds will be able to purchase and carry handguns in all 50 states. Just to recap, in case you had a hard time following along, shall not be infringed. Alright, let me know what you guys think down below in the comments. Don't forget to like this video, comment, and subscribe. And if you guys would like to continue to support me and my family through all this nonsense, and just because you simply love us. There'll be links down in the description, such as obviously the best store in the world, which is onlytacticalfans.com, and other links down there too. And as always, I appreciate you guys so much. I don't know what I would do without you. And until next time, guys, peace.